Hi, good evening, everybody. It's been a fairly long day, lots of information, lots of sidebars, and in some sense, the Indian legal LLM, it really, I mean, in terms of design, also the reason why we kept it towards the end is because it builds on the responsible AI session that all of us attend in the morning, and it also sort of builds on the Jugalbandi session which Smita and Saurabh just took us through, right? So the aim with the Indian legal LLM is essentially we did an activity where we spoke to a lot of lawyers, we spoke to different actors within the judicial system, within the, let me call it, within the larger justice system, and we tried to figure out that what are some of those tasks which could be automated for a lawyer, which could be made simple, things which take a lot of time, things which take a lot of effort, but are also made, but also it's because it's sort of entrenched in the system because of existing processes, but there is a way to facilitate and unlock that. So that's the ethos behind why we are building this for the legal community and why we need the Indian. So the agenda for today is we'll go through these four things. We'll talk about why do we need an Indian legal LLM, approaches to building an Indian legal LLM, prioritize legal tasks, and how can you and all of us come together and build this together. Now, our first results with respect to building the LLM has been fairly positive, I would say, out of some of the tasks that we are doing. So why do we still need it? We have these super powerful models, right? Like Llama 2's come out. We have GPT-4, and at least in the sense of doing some of the more routine tasks which a lawyer does on a day-to-day basis, like let's say reviewing a contract. You run it through the model, it will give you some answers, and you can do it. But then what we have seen when we are doing this is that there's a lot of hallucinations which happen the moment you put some context in. And there's so many lawyers in the room, and I think all of us have interacted with very different laws and very different parts of the legal system. So we also know that how there's a big variance in how, let's say, certain cases which come before the court would have a certain context. But on the other hand, if a contract, let's say a specific tech license is being negotiated, that would be within a certain context. So that context is missing presently from existing models, and our aim is in some sense to give that context for few legal tasks which we have identified and see where we go from there. So a quick note on limitation before I move on is that the legal tasks that we are going to talk about is by no means exhaustive. For example, we are working on 6 legal tasks, but the LLM itself, I mean, you can have many legal tasks on which it can be trained, but we felt that these 6 have taken a certain priority, so we are working with that. Approaches to building an Indian legal LLM, Prathamesh will come in and speak to you, and then I'll move on to telling you a little bit about the tasks themselves and how you can come and help build it.
Okay, thank you. I appreciate the patience. It's around 6 o'clock already. Yeah, so here we are on Sunday evening listening to why Indian legal LLM, because it's important. So GPT-4 is already great, right? How many of you have tried GPT-4 or ChatGPT? Almost all of you, right? Great. So as Atreyo was saying, there's some issues there, like hallucinations is there. Sometimes you can't send data, right? So we have seen court systems saying that no, the data can't leave this boundary, right? It has to be within whatever you want to do, bring that inside our premise. And there are some thought processes that will go away in a while, right? Like what has cloud is doing, right? Most of people initially were resistant. But eventually, like most of the systems we see deployed on cloud. But till we reach that point, I think it's important that we bring some of these LLMs in-house. So that's one thing. There is also a blog that we have written. If you can just open that link once. So these are some of the things that we did very interestingly. We tried GPT-4 and ChatGPT models on AIPE. How many lawyers here have taken AIPE? All India bar, that's nice one. Okay.
Not a practicing lawyer.
Yeah, okay, right. So we tried this thing on some of these law entrance exams, and we found, yeah, it's already there, right? Like, what's the problem? It's already. Maybe we'll take it out. We can go back to the slides, but I'll share the link, and then so some very interesting results that came out of that, which are corroborated by the studies that were done elsewhere, especially US. That yeah, for these entrance exams, it's reasoning, factual things, it's already good, right? But yeah, again, there are some improvement areas in terms of how do you apply law to a given situation. How do you kind of come up with better precedents? I'm sure you must have heard of the fake precedents things that's going on, right? So there are the challenges, right? How do you mitigate is the first point is what we have been discussing for last an hour. It's retrieval augmented system. So augment basically LLM with external knowledge. That forms the key of whatever we are doing. So the first thing. Second one is like many organizations have said, especially the government one, finance, that there is a key, or even some of the law firms, that there is a need to host LLM within an organization. It could be because of multiple reasons, cost slash data security, etc. But those are some of the ways that we believe that at least in the short run, it makes sense to build Indian legal LLM. Right. So how do you go about this? This is a slide from Atreyo. He's a leading scientist in this area. So there are mainly 4 steps here that you see from left to right. Okay, it's a very interesting slide that how this happens. So what you see, so you start from left and you go to right, and each of these steps are essentially sequential, right? I mean, you can't skip one. If you want to skip, you have to like, assume that okay, something is already there. Okay, so when you say pre-training, so that's a step number 1. It tells you like what data set, algorithms, models, etc. So very few companies have kind of compute budget to do a pre-training kind of thing. So people have done it, and it is available in some forms. So then you have, after that, you do a supervised fine-tuning. Supervised fine-tuning is where you actually take your data and then you fine-tune the pre-trained model on that data. So I mean, I'll come to more detail about this, but we are focusing mainly on supervised fine-tuning. Okay. And then you have reward modeling, which is like required for reinforcement learning, which basically decides what reward should be given for what kind of responses. That means if I give you one thing, it will if you give me 4 options, can I rank them? Hey, this response really looks nice. Number 1, number 2, number 3, number 4. Likewise. So that is the reward modeling thing. And finally is the reinforcement learning piece, where actually you have things like you can generate tokens that maximize that basically reward that you have, right? So those are independent models, but again are needed. So it's a prerequisite to do reinforcement learning. So the point I'm trying to make is models like ChatGPT or ChatLama have gone through all these 4 steps, and that's why they are very successful, right? What we are not, we do want to reach the last stage, but we want to start somewhere, which is the supervised fine tuning. That's another priority number 1. And if we get more time and data sets, then we might go to second and third. So that's what we are trying to do. A lot of people ask, okay, when you're saying Indian legal, and what are you trying to build? We are building an essentially a fine-tuned model of a base model, something like a Llama 2 or some other smaller models which can do certain tasks well. We'll talk about the tasks. Yes.
So the tasks that we are predominantly working on right now is essentially argument generation, event timeline creation, statute ingredients, issues generation, section prediction, context review. So I'll go through one of them, each of them one by one. So essentially for argument generation, the aim is pretty intuitive, right? Like a lot of times as practicing lawyers and just generally like your bread and butter is to generate arguments for your client. Whether that even in a contract, whether you're litigating before a judge. And we feel, so as of now, that's our priority number 1 task. So interestingly, a quick side note on that is when Prathamesh and I were having some of our earlier chats as to how to go about it, Prathamesh very nicely asked me that, okay, also if you're generating an argument, how do you do it? Like, as a lawyer, what do you do? And my mind immediately went into, okay, maybe sometimes I look at the facts, I look at some precedent, I'll see if that applies to the case and I have an argument. But sometimes we don't always follow such a neat linear process, right? But for building this, and that's the difference in in a lawyer's language and the sort of language which Prathamesh was speaking, is that we have to figure out how to get that intuition into the model. How does the model understand what I understand intuitively in a far more structured linear way? So I think for us, one of the first struggles was really that, and we'll actually demonstrate how we are going about it, and I think that'll give us some clarity. In terms of event timeline, I think you can, let me just go through them, Prathamesh, then you can change. For event timeline creation, essentially the ask was that a lot of times, most things in law start with a date, right? Like your cause of action, what date? Does limitation kick in, what date? So date is a very, very pivotal part of any action which you ultimately want remedy for, right? And if you see if you see a plaint, if you see a pleading, it is always date-wise, and especially for those of us who understand how a special leave petition, which is before the Honorable Supreme Court of India, how that works, is that first you have the list of dates. It's a chronological list. Then you have a synopsis, which is essentially summing up what would be your main grounds and facts of the case, but also in a somewhat chronological manner. Then the list of dates, the chronological order in which you have created, translates into the facts. And lastly, you have the grounds, which is also something which, as you're drafting, you have to weave in that chronology. So to have that first event created for you is something which is immensely beneficial. For statute ingredients, what we are doing, actually I think I'll go to statute ingredients later. For issues generation, what we are doing is think you have a set of facts, and issues generation is actually related with argument generation. It's a precursor to generating an argument. So what's essentially happening is that you have a messy set of facts, right? Like person A has said this, person B has said this, defendant A has said this, defendant B has said this, and now you're sitting either as the person who's representing your client or you're sitting as the judge. And the ask of the tool over here is that you've got this set of facts. What are the legal issues which the judge or which a lawyer who's drafting certain arguments has to keep in mind? And for sections prediction and for sections prediction, I'll come to it later. For contracts review, the understanding is that you have a legal contract. Let's say it's an immensely voluminous contract running into 200, 300 of pages, right? And you have to do a review. You have to do a first ask at what are certain risks and liabilities which crop up from that. So the point here is that this tool should be able to bring those risks and liability out to you, so that then you can spend that time and see that whether these risks and liabilities are something on which you have to spend some time and figure that out. That is that actually a risk or actually a liability. Next one. So as of now, for multiple reasons, we have prioritized these three tasks. We'll get to the reasons in some time, but I've already mentioned argument generation. Prathamesh, let's go to the next slide. Thank you. So, in argument generation, how this is the structure on which we are working. So, you have a set of facts, unadulterated facts as of now. There's no law, no date breakdown, nothing. Just facts. What that happens is that we break the facts down. The model then frames certain legal issues from those facts and also lays out the relevant sections which are coming out in that set of facts, irrespective of that actually being in the facts or not. So for example, if somebody strikes me with a hammer, now that could fall under multiple things. It could be intention to cause grievous hurt, causing grievous hurt, assault, and a bunch of other things. But ideally, this tool should list those sections out for you, and then as a lawyer, you can choose whether all, any, or none of them apply. After that is done, Prathamesh, do you want to explain this part? Should we demonstrate it to them? Yeah, so what we do is we just demonstrate how we are doing this, and I think that will give some more clarity.
I'm not sure if you can read this, but maybe yes, yeah. another case. Okay, so what's going to happen is, right, so the task is basically we want to create some instructions data about, let's say I want to train a model to generate arguments for a lawyer. How would I go about it? So the first thing would be that, okay, I need some facts on which I want to create arguments, right? So in absence of any other data sources, what we have done is we have gone past to past judgments and we have picked some of them. So maybe I can just go back to one step and show you. Yeah, so there are some of the old judgments that we have picked up. Okay, so the idea basically is get facts extracted from them. So if you look at a typical judgment, we'll start with the initial few paragraphs talking about facts of the case, right? So what we did was we just said that, okay, first we are extracting few initial paragraphs of the case as facts of the case using our rhetorical role model. So when Smita was talking earlier, we do have a model, AI model, which can give you structure of a judgment. And you can literally go, okay, this part are talking about the facts of the case, these are the issues, this is the analysis, this is defining judgment, this is relied upon, not relied upon. So we consume that model to come up with these facts. And the idea basically is that we will give this tool to experts, like law students, lawyers, people who are working in this. And they will be asking that this is the original judgment and we believe that this is the facts that have been extracted. Can you check and add if there are any missing things in this, right? So you get the facts thing correctly, right? Now the next, click on the next one. So the diagram, so we got the facts here, right? So facts are done. Now the next step is doing the legal issues framing. In legal issues framing, you basically go and so we are using, so there are some issues that are also framed in the judgment, but sometimes they are incorrectly identified. So what we do is we do some pre-annotations using GPT-4. So we ask LLM that, hey, these are the facts. Now based on that, what do you think are the right kind of issues that the court should be handling?
Without the defense, there are no issues. The plaint by itself does not require issues to be framed. For all that is admitted, there are no issues to be framed, judgment will be given. So therefore, you bring the facts with the plaint as well as what is stated in defense and then generate the issues. Otherwise, it cannot make sense.
Thank you. So one thing here.
Thank you for pointing that out. Just a quick clarification. So we are actually doing this for generating the argument. So it's not so much generating the ultimate issues which will come out after seeing plaintiffs and defendants' arguments, but just for, let's say, if I'm the plaintiff, this is just for my call. Just
more appropriate expression in such a case for a person to understand is points, the points formulated or something like that instead of issues. Issues are always identified as that which is a court's duty to do after the statement is filed. Otherwise, you don't frame issues. So therefore, that's because it's understood like that, you can say points identified by arguments.
Yeah, so one thing that helped us was, since these are past, like most of these judgments are higher court, so sometimes you do get facts as like what lower court did in that case as well. So that also helps to frame some of the legal issues because you're obviously challenging those. So that helps the model to come up with the issues that on which the court needs decision. So once you have those, so we also have a model which can extract all of the sections and the acts to which they belong to, right? So in this case, the model has extracted all these acts somehow look very relevant, and the person can go ahead and take, okay, this looks applicable, and also provide the reason why they are applicable or not applicable. And maybe you can go to next. Maybe select few. Right. So when and then this is the most trickiest part of how do you pick up the right precedent paragraphs, right? This is where all of the lot of ambiguities or the manual thing is coming into picture, that we don't want LLMs to tell you which precedents to cite, right? Because it's a very manual process, and we have categorically made a decision that no, it's not LLM's job to do a precedent search for you. Instead, what you should be doing is it should be done outside the LLM. So there should be a neural search engine which, given some facts of the case, should come, okay, these are the 4 or 5 ones that do look relevant to your case, and then based on that you have to manually, so the current process here is trying to manually copy paste some of the relevant paragraphs from certain precedents that either are cited in this case or the lawyer/expert thinks are relevant.
I can't believe that you can bring an argument or even you can generate a logical argument without understanding the legal underpinnings. So if you say that you will keep the precedents away and then I'll prepare arguments, and that could be truly deficient in the content. Because my understanding of law is what gives me the strength to say how I generate my argument. So I would want that to be married at all times when we go into preparation of arguments. Because you said that you keep the precedents away, and then there I thought there was a very serious deficit.
What I meant there was, if you look at this diagram here, the blue ones are some of the tasks that LLM need to do. That means we are training the LLM to do those tasks. So when I meant was that we don't want the precedent search to be done by LLM, but I'm saying that that's an important process, or it's an important component, as you rightly pointed out, that without that you can't generate arguments. So that's what I'm saying, that this green box there, which is doing the precedent search, needs to be done manually at the problem.
Sorry, I seem to be setting the flow, but I can't resist. Because when you see the precedent, now again, so many of the search engines of some of the popular software, say for Supreme Court in Supreme Court cases. Now you have, it's not very difficult to set the parameters. To say, you key in the keywords or what you want to know. And then you say the quorum wise. And then you say the year ones. I can limit it to which year to which year. Which court? Do I want the Supreme Court? Do I want that court? A practitioner in Kerala must be interested in knowing what the Kerala High Court says. Doesn't find an answer, then escalate it to Supreme Court. Or take it from Supreme Court and then look it down to what your court has said. And therefore, this should also get appropriate guidance for that is where human fallibilities exist, or where the refinement is lacking, and you want to therefore supplement it with what the machine can do to us, or what this can do. So therefore, help if it comes through promptings of what you can key in and then get those results. After all, yeah, see, for any case law which I want to find in a given set of facts. Let us talk about some sexual harassment case. Then you have the sections you have. They say, what is sexual harassment? They say, then in workplace, that's what it means to be. In sexual harassment in workplace where there was no physical violence visited, but there were some verbal abuses or colored expressions which created anguish. You say things like that, verbally, no physical act. Then you say Supreme Court, last 10 years, from which year to which year. Then Kerala High Court. Then you have the whole kind of cases coming one after another. Instead of making it manual, or what you think, whatever will be done manually, must be possible for you to generate on a drop-down menu. This is what you will do. What you say is which court, which year, what is the quorum, which do you want to present first, the strength of the bench. All these things can be kept one after another, the same way as you will find in any popular software for legal precedent software. So that will itself give you a guidance about how you can build it. So that's what.
Thank you so much. Just one more clarification. So essentially what we are showing is how we will be building it, in the sense that the precedent search, ultimately when the tool is ready, is not going to be manual. But for now, while we are building it, the legal issues is automated by GPT-4, section prediction is automated by GPT-4, facts is partly automated in the sense that we have a set of facts and then we are running rhetorical roles on it to even sum it down further. Precedent search is not at all automated. So we'll actually have a whole community of lawyers who will then brief and we'll tell them that, these are the ways, exactly the things that you said, that please make use of these databases, we'll even have those things. And tell them that you go about doing the precedent search like this so that we get the annotated data. And ultimately the imagination of the tool is that each of these things then could then be automated.
Come together, you have arguments generated for both the petitioner and respondents, and again these are going to be pre-annotated with GPT-4, and it will take a while for us to get both of these arguments back, but this is what we're trying to do, that whole of this argument generation process we are doing some pre-annotation at some level, and basically finally everything comes back to the place where you have so everything comes back to the place where you finally have the argument generated here in this case. So it has generated some arguments which people can go ahead and edit. No, it doesn't look correct, I need to edit. So the idea is basically you have some pre-annotations which humans will correct, and then based on that we will train a final model which will be able to generate arguments. So that's the overall story.
Just go to the next one.
On this part, I can't believe that you have not made a template for judgment writing also. You have not made a template for judgment writing.
So that's how we are imagining how the argument generation tool would be built, in the sense that how all the lawyers that we're getting, the annotators that we're getting, we have to plug them into each part of the process so that we are able to build that. Again, this is an example on the right hand side is just a plain example of a list of dates, which is fairly common across most planes, most pleadings. And on the left hand side is the copy of a first information report. So essentially this is a fairly simple application where they've just taken a set of facts and they have broken it down date-wise. You can go to the next one. For statute ingredients, again, this is something which is not fully complete, but the ultimate imagination is that whenever we are dealt with a certain section, like let's say, imagine a really complicated FCRA regulation, right, which is difficult for a lot of lawyers to understand and interpret, especially in the civil society organization context. Ideally, this tool will tell you that for this section to be triggered, there are certain essential ingredients. So for example, for 420, there has to be, you can't have that unless you have somebody who's cheating, unless you have the component of dishonest inducement. Now, this is a fairly simple example, but I hope the imagination is clear, because we have a lot of laws which are, assume some of us who are familiar with, let's say, the Indian Contract Act. A minor cannot contract. So, for example, in that, it would just, the essential ingredients list would have become a lot easier to identify. But then there are laws which are far more complex, far more complicated, where we imagine that a tool will come and be able to break it down to the sum total of its parts. For contract review, like I mentioned at the beginning, so on the left hand side, so essentially some background, this was a contract for services. So we had one consultant and we had a company. Now what we had instructed GPT-4 to do was that you run through this contract and you identify risks and liabilities for both parties. Risks and liabilities for the company, risks and liabilities for the consultant. On the right hand side is a risk which the model has identified for the consultant, and if you see on the left hand side, the clause is one of limitation of liability. Now, as such, there is nothing wrong with that clause, right? Like it's my free will as long as I'm sort of contracting within a legal framework. I can have a clause which severely restricts liability. I can have a clause which opens me up to liability theoretically. What the model has, so this is a fairly limited liability clause for the consultant, in the sense that if I sign this contract, later on, I have very little remedy towards some of the things which are mentioned here against the company. So the risk, and it's as of now a very basic risk which the model has identified, is that the consultant may not have any remedy for damages, including indirect, incidental, special, or consequential damages, and its aggregate liability may be limited to the amounts paid by the company to consultant under the agreement. There is a lot of scope, and this is really where the LLM work actually comes in. So any practicing lawyer would tell you that here there's a lot more which has to be done. Like, by itself, this is not a good enough risk. Like, you have to give some more substantiation. That is there a previous case which has held something like a limited liability clauses? Like for example, in India, you have the concept of unconscionable contracts. It's not a concept which is like in fair use across the world, but in India there is, right? So, an ideal model should be able to tell you that, okay, of course there's limitation of liability, but it also seems that it's possible that this is an unconscionable contract, because bargaining power is different. So that's the ultimate imagination of what this tool aims to do. Yeah, we can move to the. So that's on the Indian legal LLM. Before we open for questions, just a quick message. So a fundamental principle and a core value of how we are going about it is that we really need all of us to come together and build this, because firstly, and like I said, so it brings me actually back to my first point, that this is a continuation of the responsible AI session which Sachin, Deepak and Anay hosted in the morning, and after that Jugalbandi, because ultimately the thing is, see, today OpenAI is being investigated because they actually took the community, in the sense that they took the data from the community, but like didn't actually take the community in that sense, right? But the aim here is that this is not a project which we can build on our own. We need that community effort, and you can of course reach out to me separately and we'll give those details to you. But essentially we are looking for data, we are looking for legal pleadings, contracts, we are looking for, I mean, mostly around these few things, and I'm happy to have a chat about it later if anybody is interested. Yeah, so that's all folks. Thank you so much for bearing with us. We had some nice rain also in the middle. Questions if anybody asks, so we can.
Absolutely great work, pioneering stuff. So my question was with regards to the argument generation part, and specifically the manual search for the judgment. So provided if you had access to the vast judgments that Manipatra or SEC has, would you be able to, or would this legal LLM be able in near future or at any point in time be able to replicate that or automate that for lawyers?
I'll add something. So I don't think the problem is so much an ability problem, in the sense that the LLM cannot get data from there. The problem is one of annotation. So the thing is, even we do have access to those databases, right? But the problem is, if I am generating an argument for, let's say, a specific case, I would need specific judgments which, within a specific context, which as of now has not been annotated. Like the judgments has not been marked to say that this judgment is on this, so it's applying to my argument. But once that annotation process is done, the imagination is that we can use this larger repository of judgments and do exactly what you're saying.
Yeah, in my mind, see, I mean, one thing to understand is LLM can do only certain things, and we shouldn't expect it to do all the things. So, in my mind, LLMs can do the reasoning well, okay, but search is not where LLMs will shine. Information extraction is not where LLMs will shine. So, what I'm trying to say is, even if you get that data that Atreyo was saying, getting this data is getting updated, right? Every day new judgments are coming. So where is the end? There is no end, right? You can't train this model on a periodic basis because there's cost associated. So that the idea is basically you build a search engine which you can use to get the relevant information out, and then use that information to do some reasoning. And this searching should not be part of LLM. There are specialized models. Search is like, people have been working on search problem for so long, starting from basic Elasticsearch keyword based to going to the advanced embedding neural searches. There are tools available. So the idea is what Sameer was mentioning earlier. using kind of an agent's approach. This is an agent approach that you don't do everything on your own. Don't try to memorize all information out there in the world, but understand that okay, there is a tool out there which I can query and get that right information and use that information to build your arguments. That's the approach we are trying to say, that instead of okay, here are the facts, generate all arguments. No, you don't want to do that, because if you do that, then these problems of wrong, fake citations come in. We don't want to do that. We want the data to come from authentic sources which are queryable, and we want to give access to the LLM which can consume those tools. So that's really the thought process. Any other questions? Yes, please.
Sorry, I think it's an interesting way to do it. But I mean, having some experience in this process in-house for us, I mean, I'm just going to ask a few questions in terms of how you guys are dealing with it. So in this diagram is particularly interesting for me because I think the one thing you're taking out is the Western search, which is a great idea, right? But if you look at the two remaining steps, right, section prediction and legal issues framing, and let's look at issues framing for a moment, right? Section prediction is fairly linear, that you have a source of data and you're using that source of data to, generate and pick out the relevant sections. Issues framing is still a little bit more conceptual, right? You have to teach it a reasoning kind of an ability. How do you account for things like change in concepts when you have an issues framing kind of a functionality there, right? So let's say today, and I think I noticed your training process, there are certain human validations that you're doing, right, that exist today, but 5 months down the line, the law on something may drastically change, right? So how are you, is there a corrective measure for that going forward? I just wanted to check on that. The other way I was wondering is there a better way to do this than to do individual human validation on each individual case? Or is there a kind of a more proactive approach to this that's opposed to reactive?
Yeah, thanks. It's a great question. This brings me back here, and again highlighting why it's so important for community to get involved is, see, if you stop here, if you do supervised fine tuning and stop there, all of the problems that you were just mentioning will arise. The idea is, can we keep on getting feedback on this? So for example, you do this, you deploy this, you open it to all the legal community, lawyers, students, experts. And can you do this here? That you give them the options that, okay, hey, you inputted this, I came up with these 4 options. Do you think that there is some option that should be discouraged? Is there an option that should be encouraged? If you're able to do this, then your model is learning continuously. That's how OpenAI models are succeeding. Why they opened up, or why are they on top, is the user base is so large that they have access to such a great feedback data. People have been giving them data, so they're sitting literally on a gold mine. So when you reach reinforcement learning and reward modeling, that's when you would be in a position to incorporate that feedback data. But it's still a long way. I mean, we'll get there. So that's why I'm thinking, okay, currently focusing here, but when we reach there, we would be able to incorporate this feedback and it keeps on getting better. So the trends, the changes that you're suggesting, we're hoping that would get somehow incorporated.
That's great. I mean, just in terms of argument formulation, right? I see, if you look at an Indian legal LLM and applied at maturity, you're actually looking for people to rely on this for arguments, right? So often there isn't a space where you may even realize that there is something incorrect, because as a lawyer, what I'm looking for is I'm looking at a problem, and if I've seen it in the past, it's quite easy for me to reformulate the issues. But if I have not seen it in the past, what I'm using this tool for is to help me think through those problems. But at reinforcement learning, I may not even realize the delta, right? So, I mean, I guess what I'm leading to is there a more proactive way to define thinking methodologies as opposed to having to validate each instance of an output? Because that's what it seems like is happening to me. I mean, correct me if I'm mistaken.
Right. I mean, that's what I think will eventually be, because you can't, these models will not reach that expert level as humans are, right? So it's always need to be reviewed by experts. So I think we don't want to get to the point that, okay, it will not need that human validation. So I think always the case is that, okay, here is something that the more AI feels, can you validate it? Because finally they are your arguments, right? It's all just helping you is to come up with, okay, are you covering the basics? This is what the model feels. Maybe you add on your own. Right? So I think that's how it will span out with them. But I don't think there is getting away from that step of human validation. You're not intending to do that.
So it's very interesting that a lot of Indian context laws are being uploaded. I have one query surrounding around still lot of bail petitions, counters, especially the police documentation. In Andhra and Telangana we do use English, but several states are still utilizing their native languages. So how are you planning to incorporate that in a big way? And second thing is, there are judgments, so like 66B, and continuously it will be happening. Do you want to put it in custom instructions and say remove, but the time when you train it, right, it would have already been, and the deleted judgments might have had more weightage when it comes to the probability, because lot of documents are having 66B rather than relatively it is recently struck down. So how are you planning to delete such content? Is there a way or path where you can selectively remove based on few keywords? And while you are planning this LLM architecture, right, are you incorporating some tags? Per se, in future, this law becomes defunct. Press the kill button. From LLM, selectively that will get out. That data will be passed on.
So I think great two sets of questions. So on the first one, we're not tackling the multilingual thing right now. We are keeping this specifically to English just to see how it works, because if you try to solve too many problems at once, I think it can get hard. So, but yeah, we intend to do that. I think what should ideally it look like is it should look like when you say Indian legal LLM, it should support all the 22 official languages plus the what you were saying earlier, the dialects, the local dialects, etc. But yeah, I mean, it will get there. So AI for Bharat is kind of in the process of building those LLMs which understand those. So once those kind of things are out, it gives us a head start that okay, now and it's something, there's a model that understands multi languages. Now just we want to make it understand law. So maybe that is a better way to do it. So currently our starting points may be English models which understand few languages, not all. But that's how we see it evolving. So that's the first thing. On the second thing, what we believe is that any data source that gets updated should be kept out of LLM's job. So even while we say that we want to keep the sections thing here, ideally how it should be is like it should not be there. Like we should not be doing the section prediction. What you should do is there is a search engine like a precedent wherein you tell okay, these are the possible sections that are available. And if there is any section that gets removed, then that should be removed from the master database, so that it won't come in. Similarly, if something goes on the past judgment, things like India Kanun / Manupatra should take care of that, because that's not the job of LLM to understand these external things. Its job is to do more of a reasoning. That okay, you give me this information, I'll use this information, do some reasoning, and I'll give you something. So that's how we envisage this. Currently, although like section prediction is something that we believe should be done by LLM, but that is something that we believe should be like again like this, that you have past judgments, you also have all repositories of sections, and if something gets struck down, you get removed so that it will not be there in the searches, etc.
Do we have any more questions? Okay, thank you so much. For the participants, first buses will be leave, so if you all want, you all can progress towards that. Thank you so much. Have a good evening ahead.